Right, ladies and gentlemen, good afternoon and welcome to the planning portion of the agenda. We will begin with item 10, which is to note the decision of the Secretary of State for Levelling Up Housing and Communities to dismiss the appeal in relation to the enforcement notice at Whitefield Bray Ford. Mr. Kinsella.
Thank you, Chair. As the Chairman has just outlined, the appeal was dismissed. It was the result of an enforcement investigation, which resulted in an enforcement notice being served on the land. There had been a planning application as well, so the appeal themselves was against grounds A, i.e. that planning permission should be granted, and then various other grounds within the enforcement notice relating to various things such as the time to comply with the notice, that the breach hadn't in fact taken place, and that it was that the notice was not valid or not validly served. So what I have done is just to provide a little bit of context, is just to provide some photographs of the site. Because of it, it is relatively complex. So this first photograph is taken from the entrance to the site, which formed part of the enforcement notice. The authority alleged that there was a new access created, and in total there's actually two being alleged. And the first access is literally where this photograph is taken from. You can't actually see it in the shot. There is one later that puts it into a bit more context. And then the second one, you can just see on the right-hand side of the photograph there a low bank. There was an entrance created there. And during the hearing, we visited the site, and it was noted that it was clear that this second access that you can see in front of you had in fact been created. There was some discussion as whether there was an historic access there, and some aerial images were shown to sort of set that in some form of context, but the inspector wasn't convinced that it was an existing access that was necessarily adapted. But what the inspector did feel was that the main access into the site formed part of an historic access that had been amended and changed. And so you can see from the decision that one of the removal of the hedge banks had been removed from the notice, so it only referred to the single one, which is the one you can see in front of you. The inspector kept it in even though it is now being closed up, purely for the purposes of ensuring that they don't then go and open it up at a later date, so it still forms part of the notice. A further part of the enforcement notice and the appeal considerations was the erection of the building you can see in front of you, is an agricultural building. Originally there was actually a slightly smaller building on the site, and then that was formed part of the original investigation. They then submitted an application, and a larger building was then put in its place, which we raised concerns about. And this was very much the focus of the appeal. It was considered to be an isolated building. It was away from any of an existing farmsteads in the area, and there was a bit of a debate on as whether it was isolated in terms of policy. And the inspector quite helpfully sets out sort of a bit of a consideration around that on page 4 of the appeal determination. Going over to page 5, which I'm sure you've had time to read. But the inspector fundamentally concluded that it was isolated development, and there was no exceptional circumstances that warrant the erection of the building. The appellants were raising matters around animal welfare, but it was felt that the building was put in place and then the animals come after, rather than it being an animal welfare because the animals were in place in the first instance. A little bit of a nuance, but it was, the inspector considered that to be a very important consideration. There was also amendments to land levels, which you can sort of see from this photograph again. There was historically a mobile home on the site, but that had subsequently been removed during the investigations, originally by officers, but there was still some land that that had been altered, and that also formed part of the enforcement notice. And then I've just got a couple of more shots to show it in a bit of a wider context, just so members can understand it. This one is the entrance, the main entrance, where we felt there was a new access off the lane, off the track, leading to the site, and it was this access the inspector felt that was an historic access. And when we was on site, in all fairness, there was evidence of a existing post that have obviously historically may have been used for an access. So on the basis of probability, it was felt there was an entrance there longer term. And then just some wider shots of the site, just showing its isolation. The argument was that there were some buildings further along, and it almost created almost like a linear form of development, and so therefore wasn't genuinely isolated. But officers felt quite strongly that it was. So, as I say, the notice was amended, was corrected, because there was also some debate over a silo that had been brought onto the site that originally officers felt was development, but that was removed, and the inspector also, so that struck off grounds E, and as I say, the one access was also removed for the notice. But apart from that, it was a good decision, I think, in terms of consideration around that term isolation and also the exceptional circumstances test that's set out in the policy. But I'll take any questions if there are any.
Thank you. Dr. Kelly.
Thank you, Chair. Well, congratulations to the officers for successfully defending the notice. It was quite impressive, and in terms, it's good to see a well-reasoned appeal decision as well, I would have to say. And again, I think Dean's mentioned it. Paragraph 21 is quite interesting in the decision. It talks about whether there were any exceptional circumstances that would outweigh a plan-led conclusion, which is an interesting phrase. But they do not, as they only arise because the barn was built in the first place, which is an elegant way of saying it was a contrived need, putting barn there and then arguing that this was required for the animal welfare. So, good decision, Chair. I think it was well defended, so congratulations. Thank you.
Mr. Lay.
Yeah, having seen one of these type of cases just outside the park, Chairman will know exactly what I'm referring to, on a substantially bigger scale than this, on the 50-50 basis that there's non-compliance here after 9 months, I assume you're talking about having to go to court to get a court order. What I want to know is, are you prepared to pursue it to the end?
So in terms of the compliance date, I mean, it's a good point you raise. The inspector did allow them, instead of 9 months, 12 months to comply. And that was to do with the sale of livestock that was on the site. The authority is aware that the land is currently up for sale, and that had been instigated before the hearing was felt. So I'm reasonably confident that we're going to receive some compliance. However, if there isn't, then absolutely we will go through with taking it further if we have to. It's really important that we're able to show that we have a strong and robust planning service, and that's the blunt tool at the end that sometimes we have to use, which is to go through the court process.
Thank you very much. If there are no other members who wish to speak, we will now move on to development control, and this is in relation to application 621122-006 and land northeast of Higher Tippecott Farm, Brendan Linton, and Mr. Kinsella is going to present the report on this. So if it can be noted, please, that Mr. Holton is leaving the room because he's declaring an interest.
Thank you, Chair. So yes, this application proposes, it's retrospective, and it's for the change of use of land and a lean-to a mixed use of agriculture, horticulture and residential, together with the station in a touring caravan with timber frame structure. Just to set the context of the site, the application site forms part of land to the northeast of Higher Tippecott Farm, and you can see the splodger red on your screen there, just showing it in a bit of a wider context. In terms of a little bit more detail, the existing Grasslands Lane is here. Then you come into a drive. This area here that forms part of the application site is for the purposes of parking motor vehicles. There is then an access through this building around the rear, and then the caravan is stored in this location here. There is a kitchen garden, sort of vegetable growing area in this location here, and a fenced off area of land in this location here. So again, this just shows the site in some context. The plan on the left shows the site and the wider land that's owned by the applicant, which is outlined in blue. And to the right, you can see the yard for the vehicle parking, access through the building, and the areas which form part of the kitchen garden that I'll show in a bit more detail shortly. This is the elevations of the building that is housing the touring caravan, and there's also a building which has got a chicken run and covered horticultural space. You can see by the annotation on the plan that there's a mixture of materials being used in the construction of the building, ranging from sort of metal sheeting, perspex sheeting, and timber fence panels. So there's an eclectic mix of materials, and it's addressed within the report that there is some concerns with some of the materials that have been used, and in the event that members are minded to approve the application, your officers would recommend conditions to ensure that some of the offending material is removed and replaced with a more appropriate material for its context. This is a more of an historic aerial image. I think this one dates back to about 2015. It doesn't show the building in question, which is in here, but just to provide some context, this is in 2017, towards the mid, I think, 2017, showing the building here. There's an existing hedge there that, again, will be a reference point for some photographs shortly. There is a path running around the site, and then it runs through this building to go to the front. Some wider photographs of the site showing the buildings in a little bit more context. The buildings in question are in this location here. You can see an existing hedge along here, and for those with good eyesight, there's a sort of red splodge in this location here. That's like a gas canister that's on the site as well, that you might be able to get reference for with some photographs shortly. And just a zoomed in version again, just showing it in the wider context. You can see the existing lane running up the existing highway, the parking areas in here, access through here, and the main site with the caravan is in this location here. So some more detailed sites just showing the entrance to the site itself and the area where the vehicles are parked. And this is looking from the entrance into the parking yard. Access is then through this area here. This is taken from within the land, I believe, owned by the applicant, and again just shows the building that is housing the caravan, existing hedge in this location here, and the kitchen garden. And again, the kitchen garden in this location here. This shows the path walking around the site, which gains access. And this, again, just shows that gas canister I made reference to a moment ago, and access into the building. Again, just showing the general sort of nature of the construction of the building itself. And then going into the building, you can see the touring caravan. You can see an area here of washing facilities. Entrance into the site, into the building, I should say. And what you've got here is, this is the building that again is housing the touring caravan, and this is the chicken run, I think it was labelled as, an internal horticultural area, and the kitchen garden area where vegetables are grown. So you can see from the papers that the officer recommendation is one of refusal. You can also see from the report that it's considered that the proposal doesn't accord with any of the policies set within the local plan, and that is supported by the agent's comments, which I understand has been circulated to members, where they recognise that it doesn't necessarily accord with the local plan. However, personal circumstances are advanced in this case, and these can be found dealt with on pages 7 and 8 of the report. I would remind members that in terms of decision making, the first part of the process is to consider the proposal against the local plan policies, and then consider whether there are other material considerations that would outweigh any conflict with that plan. So the applicants in this instance are looking to advance personal circumstances which they consider would be sufficient to, in this instance, outweigh the policy conflict. As I said earlier, and as you can see from the report, officers, while having sympathy for the personal circumstances that have been put forward, do not feel that these necessarily outweigh the policy conflict that the proposal arises, and on that basis the application is recommended for refusal. I'll take any questions, Chair.
Thank you very much, Mr. Kinsella. We have two public speakers, the first of whom is Ms. Adams, the Chair of Brendan and Canterbury Parish Council. So, Ms. Adams, if you'd like to come to the microphone, which I hope is on. There's a button on the top. Okay. You'll have 2 minutes from when you start to speak.
Thank you. Hello, good afternoon, everyone. I am at present the chair for the Brendan and Canterbury Parish Council, and these two ladies are supporting me, are also councillors. When this application for Tom Ridd to retain his use of the caravan at Tippecott was discussed at our meeting, the councillors were unanimously in favour of supporting it for the following reasons. Tom, now 80, has lived on Exmoor all his life, having been brought up by his aunt and uncle at Tippecott, and is a real man of Exmoor. And despite his lack of formal education, he fully understands the way of life and methods of farming, and has sympathetically cared for his stock during his lifetime. This place and way of life is all he has known, and his removal from this would cause unnecessary and great distress. Having lost his partner several years ago, he made the decision to go back to live at Tippecott, where he has a barn on a few acres of land, using a caravan which he had previously used during lambing. The caravan is situated partly inside the barn, where it is not visible from the road, and the whole site is inconspicuous. We supported this application with the implicit caveat that this is to be used only for his sole use, and for as long as he is able to continue to live there, with no intention that this would ever be passed on to any other person, as testified in the letter from his daughter Sarah. He is willing to make any alterations to the structure around the caravan that would be deemed necessary. Due to the fact that he is unable to read or write, he relies on others for help with letters, documents, etc., which does create problems with fully understanding his affairs. I personally have known him for nearly 40 years, and during that time have assisted him with his paperwork. Brendan and Canterbury councillors support this application and are confident that Tom will comply with any restrictions imposed, and that as long as he is able, he will be happier living where he is with support from neighbours and friends. Thank you.
Thank you very much.
Switch off.
No, you can leave it. Thank you. Thank you very much. And our next speaker is Mr. Tim Williams, who's speaking on behalf of the applicant, Mr. Reid. Again,
Good
Mr.
afternoon.
Reid, you'll have 2 minutes from when you start to speak.
I'm here to speak on behalf of Mr. Tom Reid, my former stepfather and my sister Sarah's father. If Tom were here representing himself, this committee would require the services of a translator due to his near-extinct Exmoor dialect. If the ethos of Exmoor National Park is to conserve and enhance the cultural heritage of the national parks, then this committee is obligated to support Tom's planning application. Tom is the cultural heritage of the national park. The Reid surname synonymous with Exmoor, heroes of Lorna Doone. Tom's family have lived on Exmoor for centuries and have owned the land at Tippecott for well over 100 years. Tom's aunt's diary is in the Lynn and Exmoor Museum, so we know that on the 18th of October 1960, Tom had finished digging out a good crop of potatoes at Tippecott. On the 9th of November, 53 loads of mangolds. Tom is one of the farmers featured in James Revilius' celebrated photographs taken at Brendan Barton in 1985. An elderly gentleman called Alf lived in a caravan on the same land for about 14 years or more in the 1980s and 90s, affectionately known as Santa by us, the local children. Many residents of Brendan never knew he was living there due to the remoteness of this land. Tom's current caravan has been on the site since around 2006 and was used by Tom every spring during lambing. Tom has been living in the caravan full-time from September 2017, and the caravan was moved to the present location around 2019. No one would know it was there, as it cannot be seen from any public vantage point. Tom lives in the most ecologically sustainable way that it's possible to live. He has no need for electricity, grows and rears his own produce the way his family have always done. Tom's application is fully supported by the Parish Council and an overwhelming majority of local residents. I note that a neighbour, Mr. Percival, raises concerns regarding the sewage and also asks who will remove the caravan and temporary structure on Tom's death. In answer, Tom uses a sustainable compostable toilet, and I would like to give assurances that my sister and I would undertake the removal of the caravan and related structures on Tom's death. Another neighbour, Mr. Nutley, is concerned about the cladding on the caravan posing a fire risk. Tom is willing to replace the perspex sheeting with more appropriate materials in concert with the planning officer as well as the fire department. Tom is 80 years old and cannot read and write. The 21st century is an anathema to him. Despite his great age and lack of formal education, his management and knowledge of the agriculture and livestock at Tippecott is second to none. He has a great zest and passion for this traditional way of life and knows no other. Regrettably, this situation is causing Tom immense distress and anxiety for which he has been prescribed medication. Tom, as well as his family, friends and community, asks this committee to show leniency, compassion and discretion so that Tom can live out the remainder of his years at Tippecott, his home.
Thank you very much indeed, Mr. Reid. Right, members, the debate is now in your hands. Mr. Lay, your hand looks as though it's heading upwards. Mr. Petrinos.
Thanks. This is a hard one, isn't it?
I think that is why we've got silence amongst the very hard.
Just so I understand the legal position, I mean, the report covers the lifetime consent possibility on page 7. Is there a legal way of ensuring that that is actually, if it were deemed appropriate, would there be a legal way of ensuring that was enforceable?
So there's two ways that it could be secured. The first is through planning conditions. So you say it's a personal permission, so it's to the individual, and once the use is no longer required, it is removed from the land. The alternative, and I know it has been put forward by the agent with regards to a legal agreement, and to be honest, both do the same thing. As you will be aware, your legal agreements have a little bit more bite to them in terms of they're a legal document. But in this instance, I think officers would suggest a condition would be sufficient to be able to secure that.
A planning condition personal to the applicant. Yeah. Mr. Lay.
Yeah, as John said, a difficult one. Planning policy versus personal circumstances. Obviously, planning policy is out of the window here. There's a few things come to mind. Were we to go down the refusal route and come to a point of enforcement and eviction, committee members are totally in the blind as to whether the applicant would have the wherewithal to rehouse himself. And it'd be rather ironic that if the answer to that question was no, as an authority, we would wash our hands of that. That would be the responsibility of the neighbouring authority to rehouse him. I assume I'm correct. I guess that would be called passing the buck. Yeah, having give this thought, there is no simple answer, but on the grounds of what we've heard, you know, we're talking about an 80-year-old gentleman. No one knows how long we got left in this world, but the law of averages come into play. I'm leaning towards a personal permission, you know, for his lifetime, with the caveat that this perspex attached to this building is replaced, and we heard the last speaker say they were given undertaking to remove everything relevant to this application. Is there any way in conditions that could be ensured?
In terms of conditions, yes. Yeah. We, as I said a moment ago, you'd have a condition that was personal to the applicant, and then in the event that the use of the caravan is no longer required, it will be removed. If they don't, then that's breach of condition and we enforce against that.
Okay, so I'll take the bull by the horns and move that as a proposal, and see what happens.
I
was going to say I'll second.
Right, well, Mr. Thwaites caught my eye first, but it's been moved by Mr. Lay and seconded by Mr. Thwaites that this should be allowed, but with a personal condition, a planning condition personal to the applicant, that the caravan should be removed when it is no longer required, and that there will be conditions regarding materials. Yes? Yeah. Thank you. Right, my next speaker is Mr. Milton.
Mine was only a comment around, I think historically, if I remember rightly, we have permitted in the past with a personal condition. The one that springs to mind was a shepherd's hut just above Exford, which is there at the moment, and that was permitted here with a personal occupancy condition attached to it, wasn't it? Although that one, I believe, was for holiday use rather than permanent occupation.
Right. Now everybody wants to speak. So my next is Mr. Griffiths. No? Oh, right. In that case, I was misinformed by the chairman. Mrs. Lawrence.
Thank you, Chair. I know from the work that I did in public health, moving anybody later in life is very difficult and makes it very awkward for them because they don't necessarily understand where they're going and why they're going. Makes it very difficult for them to get into a routine that they feel familiar with. So at an age of 81, I feel not happier that he could stay where he is, living his life out, doing the things that he's done for generations. To move him unnecessarily, I think would be too much. And I think my conscience would not really want me to do that under any circumstances. So I'm very happy to support the motions on the table.
Right, thank you very much, Mrs. Lawrence. It was Mr. Kravis. Mr. Kravis.
Thank you, Chair. It was actually more of a question. Well, I'm trying to get my head around the rural workers policy and why this isn't sort of relevant, or is it because he's not working on? And one other question, while I've got the microphone on, is we're talking about the lifetime. People talk about the lifetime. Obviously, I think maybe that should be need, because I mean I would argue that the local authority, whether I presume it's whichever bit of Devon I presume it is, already has a duty to have housed him, rather than where he's living at the moment. So it might not be a case of what happens if we refuse the planning permission. It should have already been dealt with, but that's not for now, maybe. But my question is on that policy HCD9, really.
Thank you, Chair. As part of the application, no such case was really put forward for rural workers. And in terms of the scale of development, I'm trying not to speak for the applicant or their agent now, but I think in terms of the scale of operations on the site, I think there was an acceptance that they weren't going to be able to justify somebody needing to be on the site, which is one of the tests, that they'll need to be on site all of the time.
Dr. Kelly.
Yes, thank you, Chair. I deliberately didn't say very much. I wanted to see what the view was, and I understand what's being said. I'm not at all unsympathetic to what's being said. The policy decision is the correct one. I think the officer recommendation is definitely the correct one. There is a clear conflict with policy, but looking around the room, you're identifying material considerations that suggest a decision other than a plan-led decision. So I do understand that, and it's the correct process to go through, of course. To ask the question, are the material considerations, and that's what's being talked about this afternoon. So if the view is that there are material considerations that suggest we should look at an approval, I've had many years' experience, many councillors here have, of securing permissions. It's then making sure that those permissions are properly monitored. We've talked about a personal condition. We can also add a temporary condition. So there's a twofold control there, that after a certain time, and it can be renewed, of course, but after, for example, 5 years, the applicant would be expected to renew that permission. So it's a further safeguard. So subject to, my view would be that we make an amendment to what's being proposed to include a temporary condition as well as a personal condition.
I would like to hear the view of the proposer and the seconder on that.
Well, my immediate reaction would be that for an 80-year-old to be given permission until his death, that in effect would be temporary permission.
Well, until it's no longer required,
but
shall we put it that way?
If everybody wants to put in the word temporary, I've got no objection to that.
Thank you, Chair. I just wanted to come back just before you go to any vote, really. And you know, we've all said it. These are really difficult applications to deal with, aren't they? When we're looking at personal circumstances. But I do have to raise the thought process that's really important that we all think about while we're considering whether we grant approval for this proposal. So it's well founded in planning law that personal circumstances seldom outweigh local policy. So your general rule is your personal circumstance will not outweigh a policy conflict. Now that doesn't mean it can't, and that doesn't mean that we shouldn't, but we should be extraordinarily cautious about granting a personal, a temporary permission for development that otherwise, in any other circumstance, we would be saying no to. So there has been today matters around the applicant's age. I would suggest that is a matter that could be replicated quite often across Exmoor. And so would we be happy if somebody else came back with that same circumstance and said, actually, I'd quite like to live in a caravan as well, please, because I've lived and worked in Exmoor all my life. That's one thing that you need to consider. And I'm not at the moment saying that you should or shouldn't. It's just something to think about. There is the distress and the anxiety that I think has been put forward in terms of having the planning process. And again, we are all very much sympathetic to that, and we recognise that for anybody, the planning process is a really stressful process and procedure and system to navigate through. As much as I'd love to sit here and say we do all that we can to make it as simple as it can, I know it's a stressful process. So again, somebody could turn around and have the same set of circumstances. And in terms of the applicant being a part of the community, an important person in that community, again, I would suggest that could be replicated hundreds of times, potentially thousands of times on Exmoor. And you'll need to be satisfied that those sets of circumstances could not just be repeated, and this decision used against this committee saying, why are you discriminating against me? Because it appears that you seem to like this applicant, but you don't seem to like me, and I'm giving you the same set of circumstances. And so while it is extraordinarily difficult, I would advise caution in thinking about approving this application on those circumstances. But if at the end of your considerations you come to the view that you believe that they are so unique that they wouldn't or couldn't be repeated, you are of course open to come to a view that you feel those personal circumstances outweigh the policy conflict. But I do think you just need to take a moment to think carefully about those. Thank you.
I'm sure members will be thinking very carefully about those points. Right, I next have Mr. Milne.
Actually, the planning officer touched on the question I was going to ask was, what's the implications on the rest of Exmoor? I mean, are we aware of lots of other locations with this situation around and about which we could have the same issue placed in front of us and we would have to make the same tough decision? Does anybody know?
Possibly over the years. Hopeborn springs to mind, for instance, who lived in a caravan at Sheridan for 20 odd years and built an Exmoor literature around it. So there are precedents, and I suspect there will be other cases to follow. We just have to judge each case on its merits and say whether or not this is one where we believe that a judgment can be taken which might be strictly not in accordance with policy. Mr. Petrinos.
Thanks. Thanks, Mr. Kinsella, for the considerations we need to take into account. And I quite agree that the discussion so far hasn't really cut to the quick bit. I mean, but before I get on to what I was going to say, I'm against Dr. Kelly's amendment because, having just discussed the stress that the planning system puts on an applicant and the stress it's putting on an 80-year-old, it's going to be doubly stressful when it's put on an 85-year-old and perhaps a 90-year-old and a 95-year-old if he lives that long. So I don't think that, even though I can understand the rationale behind it, I don't know whether it would be a good route to follow. The report talks about the applicant either having an exemption as a rural worker, which he hasn't got because of the lack of agricultural tie, or as a local needs affordable housing. And it also says that no substantive evidence has been provided to demonstrate the need for affordable housing. But at the same time, we've heard from the statements at the beginning about the communication skills of the applicant, which I think perhaps might go part way to explaining that. So, and being aware that if we were to take a decision against the officer's recommendation, clearly we need to have a reason to do that. It strikes me that this is the one that we should perhaps focus more on, the affordable housing route, because it seems likely that this person would need a affordable home, and that this would meet the... No? Am I... That's it, I'll stop.
Sorry, yeah, just to... I think it's really important that what we don't do is fit the circumstance to the policy. So if we are wanting to consider whether there is a local, if there is an affordable need, then there is a certain amount of information we would expect to see to demonstrate that, and that hasn't been forthcoming with this application. Now, you could take the view that actually that is an option for the applicant to take, but in terms of what we've got before us today, that isn't shown, so we can't support the application. And it would be for the applicant to come back to us to say, actually, I am in affordable need, and we could have a discussion with them. Now, there's no assurances around that, but I would stay away from falling into that trap of sort of saying, well, on the face of it, it's clearly that they're in affordable need, or clearly they're a rural worker. I think everybody, the agent, has confirmed it doesn't comply with policy. So that's your starting point, and you're just looking at personal circumstance. So in that instance, it makes it relatively simple, because you're not looking at whether it fits with the plan, because it doesn't.
Thank you. So we are back to the personal circumstances issues. Mrs. Nicholson is next.
Thank you, Mr. Chairman. Yeah, we're very clear where the question is. And I think the first thing that I'd want to say is to support Mr. Petrinos. I don't, if we were to permit this for as long as Mr. Reid can live there, rather than to death so long as he can live there, then that's what we should do. I don't think we should be adding an extra in there, because the circumstances won't be different at that point. We judge every application on its own merits. That's what we're here for, not to take a precedent of this, that one, or that one. I think in terms of this application, bearing in mind that we also have to show ourselves, despite the fact that we look at every application on its own merits, we have to show that we're dealing fairly with the public and with applications. I think we could all take considerable comfort from the thought that there are very few people who would want to live in a way which is going to be quite difficult, an off-grid way of doing things. So that reduces, I think, the number of the potential for people coming and saying, well, you let that one happen. And nothing that appears to be there is likely to do, it's not going to produce concrete that will have to be removed, it's not doing anything permanent to the landscape or the site that could produce a permanent impact on the landscape. Again, that seems to me to militate against the idea of lots more like this, as it were, despite the fact that we judge each one on its merits. I had a question, which was where the decision be to permit this, the condition around the polycarbonate. Is the polycarbonate there specifically to let there be light?
I don't know, I'm afraid.
Because I would be concerned if we were ensuring that no natural light could reach the caravan.
Were we to get to that point, I think that the conditions regarding materials, which would need to be agreed by the officers, I think we would have sufficient trust in the officers to know what would be appropriate in terms of light. Right, I next have Mr. Yabsley.
Yes, we have. Chairman, it's very clear that we must stick to personal circumstances here and not try and put any other designation on the actual structure. And I would like to support my colleague on my left's words. But a slightly different twist on this. I think the process, if we turn this down, the process that this gentleman will have to go through in terms of being housed by the local authority in homeless accommodation, which might well start off in a hotel room, wherever, and then possibly in some flat or whatever, if it became available. The pressure on that type of housing at the moment in North Devon is extremely acute. If you add the stress and anxiety, and that's what we're talking about, personal stress and anxiety, into that equation, I think that helps me want to look for a way to allow him to stay where he is. Thank you, Chair.
Although I think I would caution Mr Yabsley that that bit of consideration and what a neighbouring authority may or may not do as a housing authority can't be part of the consideration that we have as the planning authority. Am I right? Okay. Right, I think I will move on if I may. The next is Mr Thwaites.
Thank you, Chairman. I think we've talked around the issue quite a lot here. I think it's if you take individual circumstances, you could cross one off as, well, somebody else has them. This is very right into what Dean was saying. But I think we have to understand that this is a combination of circumstances. It's a combination of things that occurred which make us come to the decision, whatever that decision may be. I would second the motion, so I obviously want to approve this. And I think it's those number of circumstances you have to take into account as a whole. You can't just pick them off individually and say, well, just because of his age, that doesn't apply. Let's move that one because there's bound to be somebody else of 80 years old. I've only got 8 years to go before I get to 80. But, you know, don't be like that. But the thing is, at the end of the day, you have to have a combination of circumstances, and I believe the combination of circumstances, as we understand them, leads us to go through that approval stage. Thank you.
Right, thank you. Okay, yep.
It's only a very quick one, Chair. Just for my own benefit and for the purposes of the notes, it'd be really useful to understand the actual personal circumstances that we're considering are the overriding factor. Because there's been lots of discussions about various things this afternoon, and it'd be really good to understand what are those personal circumstances.
Well, the personal circumstances that I've got at the moment are the age and the health of the applicant. Mr Lay?
Plus his inability to read or write, I suspect being moved on from there into a foreign location, you would find very hard to accommodate, but that's not a planning issue for today.
No. I hesitate slightly in including that as part of the concern. I think if we keep it to the age and health of the applicant, we're on firmer ground, to be honest. Now, if I might say so, it has been moved by Mr Lay and seconded by Mr Thwaites that we should approve this application with a planning condition personal to the applicant, which will be that the caravan would have to be removed when it is no longer required by the applicant. You've got them written down already? Oh, well.
So just in terms of if members are minded to approve it, we would recommend that you have the standard that it sort of accords with the plans. It's a standard condition that that there is the personal permission, and that once it is no longer needed for the purposes of the applicant, that it's removed within 6 months from the date in which it's last used. That there is the separate condition that it's personal to the applicant. That prior to or changing my own wording here, within a period, say 3 months, 6 months, that the perspex used is removed and is replaced with the material that's been agreed with the planning authority.
Well, I think we heard what you said about light.
Yeah, is there anything else on the perspex that will let?
Well, I think that's something we have to rely on the officers to negotiate. I think what we can't do here is to negotiate those conditions. So, yeah. So I think we leave that to the officers.
That if there is going to be any form of external lighting, just thinking about the pathway and stuff, that's submitted to the planning authority to be agreed. That permitted development rights are removed, so no further structures can be put in place. That's it, Chair.
Right, thank you. Now, I know Dr. Kelly raised the time limit issue. That wasn't taken up by any other speaker, and there was no favour I could detect on the part of the proposer and the seconder to amend their original motion. Dr. Kelly, do you wish to move a formal amendment or not?
No, providing we're satisfied that those conditions will be carefully monitored, I'm not pushing that any further forward.
Thank you very much. Right, in that case, ladies and gentlemen, it has been proposed and seconded that this application should be allowed with the planning condition and the other conditions noted by Mr. Kinsella. Is everybody clear? May I see all those in favour? Right, we've got 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Yes? Those against? 1 against? Abstaining? 1, 2, 3, 4. Okay. In that case, ladies and gentlemen, that stands approved. Thank you very much. A very interesting debate, a very difficult and rare, I would suggest, case, but thank you for that careful consideration of the issues. Thank you, ladies and gentlemen, very much for having attended the meeting. I don't know if you want to stay for the last little bit or if you'd like to slip away now, in which case we'll just pause for a second to let you go. Thank you. Right, we move to item 12, which is the applications delegated to the Chief Executive. Anything that you want to highlight, Mr. Kinsella, or should we just go through page by page?
Just very quickly, Chair. So in total there was 26 decisions, 24 received positive decisions, and of the 2 that was refused, the first can be found on page 3 of item 12, the last but one item at Ridgewood Cottage. That was refused because it was contrary to policy in that the extensions proposed were in excess of the 35% that's set out in the policy, and there was concern as a separate reason regarding the scale and the massing of those extensions and the impact that it had on the existing property. And the final one, which is it shows on page 1 on mine, but I don't know if it is on page 1. It's on the it's on the last page. Again, the last but one, which is Little Acres, that was a resubmission of an application that was previously refused. That again was refused because it was considered contrary to policy, and the authority have served an enforcement notice on that site. Thank you.
Right, a long-running saga. If you have a printed copy, our pages seem to go in reverse order, so I'm going to take them as they're numbered. Page 1. Page 1. Judy likes to keep us on our toes. Anything on page 1? Dr. Kelly.
It's not a retrospective application, so are there elements on the site that have been undertaken?
It was a retrospective application, so the caravan and the access and some of the other associated development had taken place.
Sorry, Chairman, we So anyway, Little Acres was dealt with. Anything on page 2? Page 3? Page 4? Mr. Ellicott.
On 6/14/22/101,
Yep.
is there any affordable element on the living accommodation?
Is this the one, the Exmoor Forest Inn?
Yes.
No, this so this was a scheme that sought to demolish an existing barn and then create a sort of a retail type shop use at ground floor, and then at first floor it was to provide either staff accommodation or self-contained holiday accommodation, for which permission was granted. There was no residential in that sense, no.
But it's ancillary to the use of the inn, and it's the old green tin shed building in the car park, Skittle Alley. So it's not affordable in the sense that it's ancillary to the business.
I can't quite remember what the retail element is going to be used for.
Well, I seem to remember from my recollection of the application that they meat products from the estate, which they're going to be using in the inn for food purposes, but also being able to sell it as well to other customers. So it's principally products which they're generating themselves from the estate. Right. Anything else on page 4, ladies and gentlemen? No, thank you very much. Item 13 is site visits. The reserve date, should we need to have one, will be the 28th of October, because you will remember there is not due to be a planning meeting in October because of the conference. So you're let off now until the beginning of November, unless there's some dire emergency. So the site visit for the November meeting will be on the 28th of October. Can I thank you all very much for your attendance? Great pleasure to see you, to be back again amongst you. And I will see you at the November meeting, if not before. Thank you very much.